My name is Chu Machinye, and I am your family lawyer. Skipping a spouse in favor of children or relatives is legally permissible for a wife who may will her estate directly to her children or relatives, skipping her husband. However, where the husband was legally married to her and financially dependent, or they jointly owned the property which the wife purported to give out in her will, he may challenge such a will. Talking about financial dependence, it is getting quite common, actually, for men to be financially dependent on their wives. So don't scoff when I said financially dependent on the wife. Now, the one that would bring us closer to our seats, that may bring controversy, is the one I'm going to talk about next. And that is when a will is given by a will is made in favor of a paramour or an outsider. The question is, can a man lawfully will substantial part or all of his estate to his side chick? The answer is yes, he can. But as you can easily predict, katakata go bust. When a man wills his estate to a mistress or lover by passing his wife and children, the courts would be called upon to scrutinize the will strictly. If undue influence, fraud, or lack of provision for dependents is proven, the will may be set aside, because it's not enough that you've fallen out of love with your wife. Did you fall out of love with your children? Be wise, actually. Be wise. All things may be lawful, but the Bible is very clear. Not all things that are lawful are expedient. So whilst it may be lawful for you to give your property to the one who whose bosom you warm now, who makes you happy, remember that you owe obligation to your wife and to your children. If you have been following us, we have dealt in great details with who can challenge a will. So if you are one of such persons, that is to say, if you are a surviving spouse under any kind of marriage, if you are a child, a biological child or a legally adopted child of a person who excluded you from a will, if you are a dependent, a person with some disability, or an aged parent who has been living on the resources of the person who died and he excluded you out of your will, you may be able to show a legitimate interest and a legal or moral right to inheritance, which the court may look at. Before we continue, please don't forget to click the subscribe button if you are finding this valuable. To yourself or to a friend, share and let them know that they do have rights. We'll now do what we do usually on this episode. Look at how the courts view situations like this. When a deceased person's relative complains to the court that he or she has been scorned by the testator or ignored in his will, the court will be called upon to look at and judicially consider some factors, one of which is the relationship of the complainant or plaintiff, as we say in court, with the deceased person. The financial and emotional dependence of the person disinherited would also be looked at. The court will take a look at the size and the composition of the estate. If it's such a small one-house, tiny place, you can forgive the man if he couldn't go around. But if it is massive, something should go to everybody. Then there is the cultural expectation of religious doctrines. And then, of course, evidence of unfairness, spite, or manipulation. The court may uphold or modify or completely revoke the will, depending on the facts and the circumstances. If the court is satisfied that the disinherited person has made out a good case, it may grant some of the reliefs I will talk to you about shortly. For instance, the court may declare that the will is invalid if the will was fundamentally flawed. The court may order for reasonable provision to be made to the claimant. And the court can also order a lump sum or share of the estate to be given to that spouse or to that child who was excluded, if a case is proven. Then the court may also consider probate injunctions or caveats, which are injunctive rights that are used to temporarily halt the administration of the estate until the dispute is resolved. If that child is in school, for instance, some money may be made available to the probate registrar to continue to sort out the school fees or payment for medical treatments until such a time when the issues are practically resolved or solutions are found. This is necessary to preserve dignity of life and the unity of the family and ensure that permanent scars are not created, and that the interest of all concerned is served and justice itself is served at the end. Now, these interim measures are usually useful in the circumstances in which I have just spoken about. But let me be quick to add that settlement and mediation are sometimes the very practical ways to go about solving disinheritance. Solutions can be negotiated outside the court to preserve family dignity and ensure that unity remains in the family and that permanent scars are not made permanent. Where the circumstances of the case indicate that this course will best serve the interest of all concerned, your family lawyer will guide you. And this will be my personal suggestion for the resolution of the Herbert Wigwe estate dispute. I think that all concerned, despite of the fact that cases are pending in court, should sit down and look at what will help the family to move forward. This, in my view, is essential because Herbert's father is over 90 years. The mother is also quite aged. It will be heartbreaking for some of us to see that the father is dead before the issues are resolved. Let some solution that is reasonable and common sense prevail to bring this matter to an end sooner than later. I speak of this as a family lawyer, not as one close to the family, but I think that what is right, irrespective of whose ox is God. And irrespective of who is right and who is wrong in this matter, who is right and who is wrong is not always justice. Sometimes justice is what is good, what is conscionable, what good conscience dictates. And what good conscience dictates in this matter, in my view, is to find a way to bring the family together so that the legacy and the thoughts and the whatever that Herbert stood for will remain good when each member of that family, including the children and the parents, remember him. As is customary with this podcast, we'll bring you some real-life court dramas where wills disinherited close family members and show you how the courts intervened, either to uphold the wishes of the deceased or unearth some mischief and strike down the will. Sometimes in 2003, the court decided a matter where the deceased left out his wife and children in favor of a brother. The widow challenged the will, and the court invalidated the will on the grounds of fraud and upheld the widow's claim. It seems like in that case, a will that excludes dependents may be struck down where undue influence or fraud is proven. So the brother obviously had a hand in trying to manipulate his brother into excluding the wife and children. And I think this is wickedness. In another case that was decided in 2006, a man left his estate to his last wife, excluding children from a previous marriage. They cried foul and went to court. The court upheld their challenge based on undue influence and ordered a redistribution. This woman, who was now the heartthrob of the man, as Kayan mattered this man and he had lost his sense of reasoning, he gave everything to her and left out his original children. This case shows us clearly that disinheritance of children may fail if it is motivated by spite or influence from another beneficiary who now controls the heart of a foolish lover. Then there is this story of a man who left his estate to a long-time mistress and some charitable organizations, excluding the wife and children. The court intervened and said, no, you can't abandon your wife and children in favor of your girlfriend and some charitable organizations. You should accommodate each and every one of them if you so wish, but not to leave out the ones who were closest to you. Something must have gone wrong. Let me take you a little bit back in time to 1898. In the case of Cole against Cole. The case arose in colonial Lagos at the time when English law was gradually being introduced alongside Yoruba customary law. The testator, Mr. Cole, made a will in which he attempted to dispose of property that was held as family property under Yoruba customary law. In the will, he excluded his wife and children from inheritance, choosing instead to divide his estate to individuals outside his nuclear family. This decision was challenged by his immediate family members, particularly his wife, who argued that the property in question was family property and therefore could not be validly disposed of under a will. The issues that the court had to decide included whether the testator had a right to dispose of family property under Yoruba customary law through a will, and whether a testator can validly exclude his immediate family, his wife and children, from inheriting property held under customary law. Lastly, whether English law's doctrine of testamentary freedom overrides the constraints of customary law. The court held that the will was invalid to the extent that it purported to dispose of a family property that was governed by customary law. The testator had no legal right to will away family property without the consent of the family members, or in a way that disinherited such family members. Therefore, the attempt to exclude the wife and children who were part of that family from inheritance failed, and the court held that they were entitled to the customary portion of the estate which was due to them. This confirms what I said to you earlier on, that testamentary freedom is not absolute in the Nigerian context, especially where customary law applies to specific properties. Under Yoruba family law, for instance, Yoruba customary law, for instance, family property is communally owned, and one individual, even the nominal head of the family, cannot unilaterally alienate it by a will. And so it is obvious from this that the court can actually modify a will. The court can make adjustments where a will is found not to have contained what it should contain, or where there had been fraud, where there had been manipulation, where the maker was not of sound mind, or where a custom affects the property that was purported to have been given out by a will. Lastly, we'll tell you the story of the Akinubi family. This case involved a dispute between the widow of the deceased, Mrs. Akinubi, and other family members over her husband's estate. The deceased was a Yoruba man. He had made a will that completely excluded his widow from inheriting any part of his estate, distributing his property solely to his extended family members. Under Yoruba customary law, widows traditionally have inheritance rights, though this may sometimes be limited in favor of the children that they had for the man. The widow challenged the will, arguing that her exclusion was contrary to customary law and to natural justice and good conscience. The issues that arose in the court included whether a testator can completely exclude a surviving spouse from his estate under customary law. The court also had to look at the extent to which customary law imposes obligations on a testator. The Court of Appeal held that whilst a testator has the right to dispose of property, his property via a will, customary law imposes certain moral and legal obligations towards dependents, persons who were dependent financially on him, including surviving spouses. The court further ruled that the complete exclusion, total exclusion of the widow, who perhaps had no other means of sustenance, was unreasonable and contrary to Yoruba customary law, which expects some provision for a surviving spouse to survive. The court therefore ordered that the widow be granted a reasonable share of the estate. This clearly emphasizes that testamentary freedom is not absolute. It has limits, it has boundaries of justice, boundaries of reasonableness, boundaries of good conscience and public policy. Now, my final word on this episode. When a will says no, capital no, to a spouse or a child, it is not necessarily the end, but may signal the beginning of a legal inquiry. If you have the courage, if you find the grace, the courts in Nigeria are increasingly willing to look into and sometimes override unjust exclusion and enforce fairness. The law respects a person's freedom to dispose of his property, but not at the cost of justice, not at the cost of dependency or dignity of the person. This episode has provided you a detailed exploration of why and when a testator might disinherit a spouse or child, including scenarios like adultery, waywardness, keeping a spouse in favor of children, or paramours, that is to say, side chicks, and the legal implications of each and every one of these. A stitch in time, it is said, saves 9. Rebuild and reunite your family whilst you still can. Mend the minor fault lines and cracks before they turn into fractures, which inevitably fester into open wounds when your mission here comes to an inevitable end, soon or later. Join us next Saturday on Your Family Lawyer, where we continue to make family law clear, compelling, and compassionate. Do not forget to click the subscribe button and turn on your notification bells for more interesting episodes. And for legal consultations or legal advice, please call the number on your screen or send us a WhatsApp message. Until then, please stay informed and be empowered. And by all means, be good to your family. My name is Chu Machinye, and I am your family lawyer.